We'll hear argument next in case 207622, Denez P. versus United States. Mr. Kimberly.
Thank you, Mr. Chief Justice, and may it please the Court. The Double Jeopardy Clause implicates two distinct exercises of sovereign authority. First, the authority to say what an offense is, and second, the authority to put an individual in jeopardy for committing an offense. This Court has consistently assumed the importance to the dual sovereignty doctrine of both expressions of sovereign power. The analysis thus asks not only whether the two law-giving entities draw their authority from separate sovereigns, but also whether the two law-enforcing entities do so. The government disagrees. It says that the separateness of the offense-defining entities is all that matters. But that position would invite the precise abuses that the Double Jeopardy Clause was intended to prevent. And the CFR courts themselves provide the evidence. Assault, for an example, is an offense under both tribal law and the BIA's regulatory criminal code. According to the government, if petitioner had gone to trial rather than taking a plea on the tribal offense and he had been acquitted, the very same prosecutor would have been free the very next day to bring a successive prosecution for a substantively identical offense, this time having honed his case and refined his proof based on the lessons learned in the first prosecution. That is not an outcome that the framers of the Double Jeopardy Clause would have thought tolerable. In arguing otherwise, the government focuses on a single word, offense, which it takes entirely in isolation and to which it applies rigid dictionary definitions. But the Bill of Rights prevents not only transgressions of the amendment's literal terms, but also governmental efforts to circumvent their protections. Blockberger itself embodies this anti-circumvention principle. It holds that technically different offenses, codified in different code sections, comprising different elements, nonetheless may constitute conceptually the same offense, the lesser included of the other. And our position is that the same Blockberger rule ought to apply anytime a single sovereign undertakes successive prosecutions, regardless whether separate sovereigns have defined the respective offenses. And I welcome the Court's questions.
Mr. Kimberly, just so that I understand what you mean by we have to take the prosecution, the source of the prosecution into account. Let's say prior to trial, the tribe charges petitioner here. And on day one, on day two, the federal government charges petitioner. Are those two separate offenses with which he's being charged?
These are both charges in the CFR court?
One in CFR court, one in federal district court.
I think those are not the same offense, Your Honor, because it would be the tribe bringing the charge. I think what distinguishes this case...
No, that's not what I'm saying. The tribe, there's a charge under tribal law. Mm-hmm. That's charged for the same activity, just what we're talking about here. But before trial, the federal prosecutor charges under federal law, just as you have here, but there is no trial yet. Are those two separate offenses?
If I'm understanding Your Honor's hypothetical correctly, it's a tribe charging one offense. It's the federal government charging a federal offense.
Exact same charges we have here.
Before jeopardy has attached. It sounds to me like those are separate offenses to which the dual sovereignty doctrine would apply.
Okay, now what undoes that? If, let's say, after that, you reach you're tried in the CFR court, and we have what we have, the outcome we have here. Then you have a trial in federal court. What changes the fact that you have two separate offenses?
Well, I think, so there are two ways of answering this. I think the first way of answering this is to say that when the prosecuting entity the first time is a federal instrumentality that is relying on federal law to authorize a federal officer to prosecute a tribal offense in federal court, that is in effect the United States making the offense its own. After all, we need in the CFR court the operation of a federal law. Here it's 11 CFR 11.108 to make the tribal offense enforceable by a federal officer in federal court. And that process, the court could say, in a sense, imbues the offense with, at least in part, federal character. And that is distinct, I think, if I was understanding Your Honor's hypothetical, it's distinct from when a tribe in a tribal court pursues a prosecution for that same offense.
Thank you.
Is that your only difference? Going back to our decision in Wheeler, the court in Wheeler went through quite a number of ways in which the Navajo tribal court at issue was subject to ultimate federal control. And I want to know what you see as the difference between the federal control recognized by us in Wheeler and the federal control at issue here in CFR courts.
Well, I think the question in Wheeler, Your Honor, was just whether the tribes actually constitute separate sovereigns for purposes of the dual sovereignty doctrine. And so in undertaking that analysis, the court looked, as it later described it in Sanchez Valle, as the well springs of the authority that the tribe has both to define and punish crimes. The court acknowledged that there is congressional control over the tribes in certain actions that they can take, but that did not extinguish the core source of the authority that tribes have for defining and prosecuting offenses.
So tell me what distinguishes it here.
The question here is somewhat different. It's accepting that the tribes in the United States are separate sovereigns. It's who is bringing its sovereign, which of those two is bringing its sovereign authority to bear in prosecutions brought in the CFR courts. And our position is that it must be federal, because the prosecutor in this case, the prosecutor in the Mountain Ute Tribe CFR court, is a federal officer answerable to federal authorities. He is not a tribal officer answerable to tribal authorities. He draws his authority in the CFR to prosecute, and the CFR court draws its authority to punish from the Code of Federal Regulations and from the United States Code authorizing the promulgation of those regulations.
So would it have mattered if the tribe had contracted with the government to provide the prosecutor? The tribe had actually provided the prosecutor.
I think the answer may well be yes, Your Honor. If the tribe were furnishing the prosecutor such that the prosecutor was answerable to tribal authorities, so that one could accurately say that the prosecutorial discretion being exercised, the decision what charges to bring, what penalties to seek, what leniency to grant, what plea deal to negotiate, were in fact expressions of tribal sovereignty and tribal authority, then I think the answer is we may well be in a different situation. But
so it'd be an easy fix if you were to win in this case. CFR courts could continue so long as the prosecutor was tribally controlled.
I think that's right, and I would say that I think there are two easy fixes, Your Honor, both of which are substantially more respectful of tribal sovereignty than what happened here. First, you could have a 638 contract that allows the tribe to control and bring the prosecutions. Beyond that, you could also just have the simple administrative fix of reallocating the resources for these CFR courts to grants to the tribes to establish their own judicial system.
There already are. These tribes are too small to make use of those grants.
Well, I think the
grants aren't big enough. They're not big enough in light of the poverty of the tribes.
Well, that's right, but so the suggestion is rather than the federal government spending money on CFR courts, the federal government can spend money to allow these tribes to band together the way that they do under the CFR courts already to create tribal judicial systems of their own. In either event, either of those fixes would be more respectful of tribal sovereignty than forcing tribes to accept the federal government's taking over of responsibility to bring prosecutions on behalf of the tribes, which necessarily federalizes the prosecutions. Because, again, the prosecutors are, in this case, and in the Ute Mountain Ute Tribe CFR Court, are answerable to federal authorities.
Mr. Kimberly, do you think, well, let me ask you this, why aren't you making the argument that the tribal crimes have been assimilated as federal crimes? Because if that were true, then you have two federal crimes, and you're just looking at the block record, right? Even under the government's theory. Do you think that would be a winning argument if you made it?
I think it would be a winning argument, Your Honor, and I think I would feel comfortable analogizing to the assimilation of state crimes under the Assimilative Crimes Act or the Major Crimes Act. I think what's a little different is here we know, for example, that petitioner was in fact charged with a violation of the Ute Mountain Ute Code. When an individual is charged under an assimilative crime under federal law, he or she is charged actually with the federal crime. Well,
so it's not assimilated. So you think it's not the same thing?
Well, I'm sorry. So to be clear, our position is that when a federal officer is exercising federal authority in a federal court to prosecute a criminal offense of another sovereign, it takes an exercise of federal legal power to do that, and we have that at 25 CFR 11.108, and that in effect does imbue for double jeopardy the offense.
But I thought that you were making an act and enforce argument. I didn't understand you to be disputing that this crime was a tribal crime. I understood you to be seeing a distinction between the regulatory crimes and the crimes that were crimes that came from the wellspring of the tribe's law. I just wanted, that is an important point to me, so I want to make sure I understand your position.
And so I'm not sure I understand.
Are you seeing a distinction between the federal regulatory crimes and the tribal crimes, or are you arguing that, say, 25 CFR 11.449 functionally assimilates the tribal crimes into federal law like the Assimilation Act does for some state crimes?
We're not making a formal assimilation argument. I think it would be perfectly acceptable if the court wants to take that approach, but our principal position is that it doesn't matter, and that for double jeopardy purposes, there's no meaningful distinction.
Well, it may not make a meaningful distinction here. I acknowledge that, but I do want to follow up on this question. And I don't want to revisit Gamble. I was in dissent there, so I must have been wrong. But here, am I correct that the tribal crimes are only enforceable in CFR court with the assent of the Secretary of the Treasury?
That's exactly right, Your Honor, and that comes from, it's duplicative of 25 CFR 11.449. It's also 11.108, which is the provision that requires approval of this.
And historically, as I understand it, that was an important feature of the law because the federal government, in its infinite wisdom, didn't want every tribal crime to be enforceable because they thought some of them were not sufficiently worthy of federal respect. Is that right?
I think that's part of it. If I may supplement that answer, Your Honor, I think it's also because the BIA itself has always understood that the CFR courts and prosecutions taking place within them are fundamentally federal and therefore must be consistent with federal law, and therefore a review of tribal crimes to ensure consistency with federal requirements for the operation of federal instrumentalities were recognized.
Can a federal criminal statute include a racial classification?
It's a fair question, Your Honor. I think there is a serious constitutional equal protection question about whether or not that's the case.
So if we were to hold that this provision of the tribal code was really federal law, we would have to confront that question, wouldn't we?
Well, I think you've got to confront that. One, I should be clear, that isn't a question presented here. I think the court would have to confront that question perhaps in a future case, regardless, because there is a federal regulatory criminal code adopted by the BIA independent of tribal laws, and that too has the same racial classification as a precondition to its application.
If I might return to what I think of as the Barkas exception argument that I take you to be making, that the court recognized that there are some instances where, even if they are nominally separate sovereigns, they function hand in glove to the point where we will find double jeopardy violations to occur even if they are nominally pursued by separate sovereigns. And the federal government makes the argument here that the Barkas exception shouldn't apply because they didn't really get two bites at the apple here. That your client pled guilty, and that therefore there's no worry, double jeopardy concern that we should attach to this case.
Well, this court in Green addressed the question whether it makes any difference whether a criminal defendant is acquitted or convicted, rejected that distinction as relevant to the double jeopardy question. There's no basis, certainly in this court's cases, or I think sort of our general understanding of the purposes of the double jeopardy clause to say it makes any difference whether he was convicted the first time or acquitted. I would say more generally, of course, there's 25 U.S.C. 2810, which calls on federal authorities to coordinate these sorts of things. I would submit no question that the BIA prosecutor is a federal prosecutor. He's directed by Congress to coordinate with the U.S. Attorney's Office with concurrent jurisdiction. That office with concurrent jurisdiction exercising the exact same sovereign power brought under Barkas a charge for the same offense, and that is the heartland of the double jeopardy clause, and so I just don't see a distinction on the basis that he was convicted the first time.
Is the prosecutor in the CFR court is appointed by the federal government, and does he have to get the federal government's approval for each case that he brings under tribal law?
In the sense that a prosecutor has to get approval to bring prosecutions, yes, he would seek it from the federal government.
Well, I don't even mean in the sense that. I mean, imagine you are a CFR prosecutor. You've been appointed by the federal government, but confirmed by the tribe, I take it. And now you want to bring a case. Do you have to go to Washington or somewhere, or the U.S. attorney, and say, can I do it?
I think I'm not aware of any practical such requirement.
All right. And is it the case that the requirement there differs in any respect from the requirement of the prosecutor in what is tribal courts throughout the nation?
In other words, does a tribal prosecutor in tribal court have to get tribal approval?
Does whatever approval the individual needs, the CFR prosecutor needs, get, if he has to get any, now I think he doesn't have to get any, does his role differ in any way from a prosecutor in a tribal court?
I mean, not...
Is the only thing there that he's appointed by, or is there something else? He's appointed by, with the confirmation by the tribe, he's appointed by the federal government. Is there any other way in which he differs from a tribal court prosecutor that you believe is important?
Yes, and I think it flows from the fact that
what is that?
That he is appointed by
what is that?
What it means is that that the United States public policy and public safety prerogatives and priorities are what drive that individual's prosecuting.
Okay, I've got the same point. He's appointed by the federal government. Well, you have read, as I've read, the scholar's brief. And it says, sure, there were a lot of tribal officials in 1883 appointed by the federal government. And moreover, they quote from the history and reports and so forth and so on, and you've read them, and they all say, just like the law is tribal in nature. I mean, you read all those.
You will hear argument this morning in Case 20-1775, Arizona versus San Francisco. We'll hear argument next in Case 20-7620.
Months, not 300.
Tribe doesn't actually care about prosecution of drug crimes. They really want to focus prosecutorial resources on other issues like sexual assault crimes. Those sorts of decisions in the system that has been set up by the BIA are necessarily federal. Now, as a matter of comedy, of course it's true that federal officials can take into account the interests expressed by tribes, but nonetheless, those priority-setting decisions are inherently federal.
The tribe seems to think of these courts as very tribal. I mean, there's a tribal brief, and the tribal brief is on the government's side, and it says these are our courts. And I mean, in a way, it's sort of like saying they're suffering from false consciousness. What your argument?
Well,
I mean, they believe these are their courts.
They believe it is certainly true that they rely on these courts to enforce their criminal laws. There's no question about that. But and a tribe can make the sovereign decision to allocate responsibility for enforcement of their laws to the United States. But when they do that, that is, so far as the Double Jeopardy Clause is concerned, that is so far as their exercise of sovereignty goes.
Why? I mean, if we just look to what the law is, I think the law is a tribal law. Now, if we go back.
Your best. You've got to try Kachava. Kachava is the world.
Someone extremely qualified.
Let's bring in Chief White House Correspondent Nate. Already on the court, it would be the first at D.C. Federal Appeal White House. The president's pick is 51-year-old Ketanji Brown Jackson, a D.C. Federal Appeals Court judge, and if confirmed, she would become the first black woman on the nation's highest court. Judge Jackson clerked for Justice Breyer during the 1999-2000 term, and she graduated from Harvard Law School. It was 2 years ago to this day, the CBS News Democratic presidential debate, our debate that President Biden promised to nominate a black woman to the High Court for the first time in history. Jackson's confirmation would make history in other ways as well. With Clarence Thomas already on the court, it would be the first time 2 black justices would serve at the same time, and it would be the first time that 4 women would serve on the court at the same time, with Sonia Sotomayor, Elena Kagan, Amy Coney Barrett, and Jackson. Let's bring in Chief White House Correspondent Nancy Cordes. And Nancy, this is a campaign promise fulfilled.
It is, and President Biden said he was looking for someone with exceptional credentials, and that's what he's getting in Ketanji Brown Jackson, Nora, a federal judge for nearly a decade, the former vice chair of the U.S. Sentencing Commission, an attorney in private practice for years, and perhaps most crucially, a former public defender, just like the man who nominated her, President Biden. She would be the first person to bring that kind of experience, a criminal defense attorney background, since Thurgood Marshall.
All right, Nancy Cordes, now let's hear from the President of the United States.
Today, as we watch freedom and liberty under attack abroad, I'm here to fulfill my responsibilities under the Constitution to preserve freedom and liberty here in the United States of America. And it's my honor to introduce to the country a daughter of former public school teachers, a proven consensus builder, an accomplished lawyer, a distinguished jurist, one of the nation's most prestigious courts. My nominee for the United States Supreme Court is Judge Ketanji Jackson. You know, 4 weeks ago, when a member of the court, a friend of mine, we used to work together in the Senate, Justice Stephen Breyer, announced his retirement, I said then, choosing someone to serve on the United States Supreme Court is one of the most serious constitutional responsibility a president has, and I mean it. I promised the process would be rigorous, that I would select a nominee worthy of Justice Breyer's legacy of excellence and decency. Someone extremely qualified, with a brilliant legal mind, with the utmost character and integrity, which are equally as important. And though I would bring to this decision, my perspective as a lawyer, former constitutional law professor, chairman of the Judiciary Committee for many, many years, and I'm almost reluctant to say it, someone who's presided over more Supreme Court nominations than almost anyone living today, which makes me 28 years old. I started doing it when I was 32. And who has devoted much of my career to thinking about the Constitution and the role of the Supreme Court. With that perspective, I carefully studied the record of candidates. I've invited senators of both political parties to offer their ideas and points of view, and I've met with a number of them. As a result, because I truly respect not only the consent, I know they give consent, but it says, the Constitution says advice and consent. And I sought the advice of Democrats and Republicans. I've consulted with leading legal scholars and lawyers, and I've been fortunate to have the advice of the Vice President Harris. I mean this sincerely, an exceptional lawyer, a former Attorney General in California, and a former member of the Senate Judiciary Committee. And during this process, I looked for someone who, like Justice Breyer, has a pragmatic understanding that the law must work for the American people. Someone who has historical perspective to understand that the Constitution is a resilient charter of liberty. Someone with the wisdom to appreciate that the Constitution protects certain inalienable rights. Rights that fall within the most fundamental personal freedoms that our society recognizes. And someone with extraordinary character will bring to the Supreme Court an independent mind, uncompromising integrity, and with a strong moral compass and the courage to stand up for what she thinks is right. For too long, our government, our courts haven't looked like America. I believe it's time that we have a court that reflects the full talents and greatness
Next, in 21A240, Biden, President of the United States versus Missouri, and the consolidated case. Mr. Fletcher.
Thank you, Mr. Chief Justice, and may it please the court. Hospitals, nursing homes, and other Medicare and Medicaid providers serve patients who are especially vulnerable to COVID-19 in settings that are especially conducive to the spread of the virus. The Secretary required those providers to make
But putting that aside,
in Houston may actually be counterproductive.
you know what? Like, basically, the one thing you can't do is to kill your patients. So you have to get vaccinated.
COVID-19 danger.